Yeah, right. Hi, everyone. Good afternoon, and welcome to the 2017-2018 Kirkwood Moot Court Competition Finals. We're really excited to have you all here to hear this argument. I'm Joseph DeMott. I'm one of the presidents of this year's competition, along with Jace Yarbrough. And I'd like to start off just by saying what a great competition it was. We had 19 teams of 2 that participated, read a lot of great briefs, heard a lot of great arguments. And so I'd start off just with a round of applause for everyone who participated. I'd also like to thank our moot court board. In addition to Jace and me, there were 8 other students who helped with the logistics of the earlier rounds, helped listen to participants practicing their arguments, gave feedback, and well, right. So actually, I'd like to thank in a special way our 2 vice presidents, Matt Getz and Nicole Allen. Nicole was my partner in last year's competition. Matt was Jace's partner. They helped us select the case way back in August. They helped us draft pieces of the dissent. It was a 3-0 Ninth Circuit decision, so we wrote a dissent that was just for the purpose of the competition. They both chipped in very graciously with all that. So big thank you to the board. Our judges this evening are the Honorable David Tatel from the D.C. Circuit, the Honorable Pamela Harris from the 4th Circuit, and the Honorable Allison Ide from the 10th Circuit. Finally, just a few kind of housekeeping details. No cell phones at all. Please just take a minute to silence it. And please, even if it's silent, don't be looking at it during the competition or taking photos or anything. Just leave it away for an hour now. A couple other things. We do have a couple seats here. I see 1 in the middle, 2 in the front, a couple back there. So if you're standing and you'd like a seat, please feel free to come down. Also, it's a 1-hour competition, so please stay for the whole thing and stick around after the arguments. The judges are going to announce 3 awards at the end. There will be 1 award for the best overall team, another award for the best brief, which the judges have already received about a week ago and read and scored, and then 1 award for the best individual oralist. We also have a few awards from previous rounds, and so Jace is going to come up and help me with that.
So there's been a lot that's happened that you guys haven't seen in terms of the competition. We've had 3 nights of argument and lots of grading of briefs, so the awards we're about to give out are for that portion. So to begin, for Best Oralist up to this point, congratulations to Catherine Brennan and Helen Lawless. If you guys would come on.
Wait, get your picture. Get your cheesy picture.
For Best Petitioner's Brief, Jonathan Marshall and Liz Klein. Best Respondent's Brief goes to Nathaniel Rubin and Brian Barron.
right, and last but certainly not least, I just want to say a big thank you to our faculty co-directors, Randy Fenner and Lisa Pearson.
Wait, you want to take a picture?
Yeah, I just want to add, Randy and Lisa have been doing this for about 3 decades. They do a wonderful, wonderful job every year. And we've learned just a tremendous amount from them, as have the participants. So thank you again to Randy and Lisa.
The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court. The attorneys who will answer the calendar in the case of National Institute of Family and Life Advocates v. Becerra are Sammy Schatz and Dennis Martin for National Institute of Family and Life Advocates, and Mark Crass and Jane Kessner for Javier Becerra. Please be seated.
Your Honor, may I begin?
Yes, you proceed.
Mr. Chief Justice, and may it please the Court, I, Samson Schatz, along with my co-counsel, Dennis Martin, represent the petitioners. I will argue today that California's mandatory notice deserves strict scrutiny. Mr. Martin will discuss how the law fails not only strict scrutiny, but even intermediate scrutiny. In addition, Your Honors, Mr. Martin will ask to reserve 4 minutes of his time for rebuttal. Your Honors, no one disputes that the mandatory notice is a content-based regulation on its face. And as a content-based regulation, this court should apply strict scrutiny for either one of 2 reasons. First, because the law constitutes viewpoint discrimination, the most pernicious form of content-based regulation. And 2, simply because, as this court reiterated in Reed v. Town of Gilbert, content-based laws get strict scrutiny on their own, and none of the exceptions apply.
Now, your argument that it's viewpoint discriminatory rests on the proposition that the statute is that the legislature has a pro-choice agenda, right?
No, Your
A
Honor.
pro-choice ideology, that's not your argument?
We
Your brief seems heavily to rest on that proposition.
Your Honor, we do believe that the mandatory notice compels our pro-life clinics to convey the essence.
No, that wasn't my question. My question was that your brief asserts repeatedly that the legislature, in enacting the statute, had a pro-choice agenda.
Yes, Your Honor.
And my question to you is, I thought the respondent's brief fairly effectively responded to that by pointing out that the statute is abortion neutral on its face, and the fact that the state chose to fund abortion simply shows that it chose to ensure that all women had an equal right to a fundamental right. And that seemed pretty persuasive to me.
Well, Your Honor, we think that the purpose and the effect of the law make clear that the law's purpose was to target pro-life clinics, and that's what it does in its effect. There are numerous healthcare providers that are omitted.
But you haven't answered my question about the ideology part of it. That seems such an important part of your brief. So suppose, for example, I don't accept the notion that this statute, that the legislature had a pro-choice agenda. Let's just assume I don't. Then how do you win your case?
Your Honor, this court does not need to accept that the law is ideological or that the message is ideological on its face in order to agree with us that the purpose and the effect of the law is to target pro-life clinics. Again, the practical effect of the law is such that the only clinics that are regulated by this law that are required to put this mandatory notice on its walls are pro-life clinics. And what illustrates that fact is the fact that the state fails to name a single non-religious healthcare provider that is regulated by this mandatory notice.
I thought, won't their response to that be that there's just really no point in having clinics who are already participating in these public assistance programs put up a notice saying effectively what they're doing already? I mean, the reason that the law skews in that way is because some religious providers refuse to participate in the federal and the state funding programs, right?
Well, Your Honor, the state maintains that this is a generally applicable law that applies to all pregnancy health care clinics, minus the ones that are subscribed to the state's viewpoint on abortion and contraception and therefore participate in the state's program.
Is the state's viewpoint, when you say the state's viewpoint, that is, the viewpoint is California has public programs that provide immediate, free or low-cost access to comprehensive family planning services?
No, Your Honor. The authors of the bill purposefully situate this law within the quote-unquote proud legacy of the state's pro-choice policy.
See, now you're back to it being pro-choice. You just told me that you didn't need to make that point to win your case.
Your Honor, we don't...
And it seems to me you either need to defend your argument that it's pro-choice, or you need to explain to us how you can win if it isn't. And that's where I thought you were going, but you just went back to it being pro-choice, and I just don't understand your argument if you haven't effectively responded to what the state is saying in its brief.
Well, Your Honor, there are two ways that the pro-choice bent of the law could come into play. One is the idea that the mandatory notice is on its face an ideological statement. And
why is that?
Your Honor, we don't believe that the court needs to agree with us that that's the case.
Well, okay, let's assume you're right, but I still want to know why.
Well, Your Honor, it requires pro-life clinics.
It all it does is require your clients to post a notice. In fact, you could just put up the copy of the statute, right? You could just put that on the wall. You could post the statute.
As long as it was...
There's nothing else that in the right type, right?
Correct.
8.5 by 11.
And all the correct languages, Your Honor.
Well, no, you just post the statute. Nothing else.
Well, Your Honor...
Do you not think that would satisfy the law?
No, Your Honor.
And in addition, you could post all kinds of anti-abortion literature around it. You know, pictures of pretty babies, and it would be very effective, actually. Right?
Your
Do
Honor,
you think the state would prohibit you from doing that?
Your Honor, this court has rejected that the argument that a speaker, when compelled to speak by the state words that they don't want to say, can simply place a bumper sticker, for example, in Woolley, right next to the live free or die words and disclaim that message. This court has rejected
That's a good point. Right.
that as an argument for why compelled speech should be allowed.
Of course, the difference between this case and Woolley is that in Woolley, the license plate was carrying a state message, right? Live free or die. This is just a fact.
Well, Your Honor, in Riley v. National Federation of the Blind, this court said that compelling a factual statement, that there really isn't a meaningful difference between compelling a speaker to convey a factual statement or perhaps one that is more blatantly ideological, because it still could be used to burden disfavored speakers. And that's what's happening here today. We can concede for the purpose of argument that the mandatory notice is factual, but it's still being applied and to target pro-life clinics. And again, part of...
Can I, just to be clear, and I think this goes back to what Justice Tatel was asking, so it is necessary for you to win. You keep coming back to this. If the idea that this is being targeted at pro-life clinics because they are pro-life clinics, that is essential to your argument.
Yes, Your Honor, and we believe that the record, both the effect, as I said, of these tremendous omissions of all these healthcare providers that are listed in our brief, and the legislative record make clear that the purpose of this law is to target pro-life clinics.
But what if that was not the case? What if you lose on that, I guess, is Justice Harris's question. Do you have to win on that point to win the case, or is it sufficient to show that this is compelled speech? Do you have to have the targeting point?
Your Honor, we think that the targeting point is critical to our argument that this is viewpoint discrimination and therefore deserves strict scrutiny as viewpoint discrimination. But going to the second reason why this court can and should apply strict scrutiny is simply the fact that it is content-based. It is a content-based regulation. And as this court said in Reed, the specific concern with content-based regulations is that content-based regulations can be enforced in a way to burden disfavored speakers.
But I guess my question for you about that argument is what the limits are. There are not a million, I shouldn't exaggerate, but there are many, many requirements that businesses and professional establishment post certain factual notices. Public accommodations sometimes are required to post information about anti-discrimination laws. There's a phone number to call if you think your rights have been violated. This is just not employers who have to post messages about union rights and labor rights. Any one of those entities could say, I don't agree with that. I don't think that I shouldn't be allowed to discriminate, or I don't think unions should have these rights. How are those cases different?
Well, Your Honor, this is a concern that a number of the justices in Reed v. Town of Gilbert had. This was the reason that Justice Kagan concurred in only the judgment, and she posited a test that was perhaps more limited in that it would only apply strict scrutiny where there is a realistic possibility that suppression of ideas are afoot. And even under that more limited test, we would...
But so then you're coming back to your first argument again, that this is targeting. I thought now we were talking about a separate argument. Even if there's not targeting, this is problematic just because it is a content-based compelled speech.
Well, Your Honor, they are separate in the sense that it's not necessary for this court to recognize that the evidence of purpose and effect amount to viewpoint discrimination. It's only necessary for the court to recognize that evidence raises the realistic possibility that suppression is afoot, or that the law would be used or enforced in a way that would suppress disfavored viewpoints.
Finish your sentence, and then I'll
Your Honor, I would just add there are numerous exceptions to the content-based approach that would cover some of the laws that I think you are discussing. For example, commercial speech, laws.
Okay, then why you brought it up? Why is this not professional speech? Why isn't this just in a different category altogether, and you're just entirely wrong going down this path?
Your Honor, this court has never recognized a professional speech doctrine. Is that your Honor's asking?
I mean,
about
why
professional
isn't this okay? And maybe let's just call it commercial speech, because I know you take issue with the terminology of professional speech, but the court has certainly recognized commercial speech. So how about that?
Your Honor, first of all, those two doctrines are different. So commercial speech doctrine.
Well, commercial speech is not before us here, is it?
No, Your Honor. The Ninth Circuit held that this
So
law.
why don't you just talk about professional speech?
Yes, Your Honor. this court has never recognized a professional speech doctrine. This court, as a purely doctrinal matter, this court said in Brown v. Entertainment Merchants Association and United States v. Stevens that this court is getting out of the business of creating new categorical exceptions to the First Amendment.
Can you win your case if we think this is professional speech?
Yes, Your Honor, because presumably, at least as the Ninth Circuit applied the professional speech doctrine.
Well, but that's the Ninth Circuit. We granted cert in this case for a very good reason. Let me ask you a broader...
Your words, not mine.
Yeah, definitely. Let me ask you a broader question. Both sides have very carefully and effectively cast your arguments in terms of these standards of review, strict scrutiny, intermediate scrutiny, compelled speech, all these rules that we've written over the years, which, we write them because they sound objective, but when you apply them, they really aren't. I personally find them very unsatisfying. What would you think if this court simply got to the core of the issue and said, look, both sides have serious interests here. Both sides do. So let's balance them. Let's just balance. We'll take a look. What is the state's interest? We'll balance it against the state's interest in disclosure. We'll balance it against the clinic's interest in free speech and decide whether the state's interest is so important that it can overpower the clinic's interest. It'll be a simple approach. Everyone will understand what we're doing. Why shouldn't we just do that?
Well, there are two responses to that question, Your Honor. The first is that even if the court were to do that, to just balance the interests, we would win. And the reason...
That was going to be my next question. So what's your second reason?
The other point, Your Honor, is that is precisely what the court said it wasn't going to do in Brown v. Entertainment Merchants Association.
Well, but we're free to change that. And I've explained to you that I find these standards very unsatisfying. Strict versus intermediate, compelling versus substantial. As I said, those words sound good on paper, but they don't really help us. That's why I think we should get back to the core of the question. So if we were to do that, go back to your first point. Why would you win?
We win, Your Honor, because the state has tremendous, almost plenary power to regulate the conduct of professionals. And that does not include the power to regulate speech.
It's so non-burdensome what they're asking you to do or telling you to do. I mean, you don't even have to put it on your wall. Am I reading this right? You can actually just package it with all the other disclosures that people have to make, all the paperwork you do when you go to a medical facility, just stick it in that big packet and people check the box. I mean, it just doesn't seem terribly burdensome. They're not stopping the people who work at these clinics from saying everything they might believe about the benefits of childbirth as opposed to abortion. As Justice Tatel said, from posting information and advocacy for childbirth on their walls. It's just a piece of paper you have to give someone when they check in or check out. You can do it after you've already had a full discussion with them.
Your Honors, I see my time is up. May I briefly
You can
respond?
answer the question.
Your Honors, Petitioner's pro-life clinics have an ideological and religious motivation to engage in the life-affirming advocacy that they do, and to be...
Nobody's stopping them.
Well, Your Honor, to be required to utter the very words...
To utter a word. They just have to, and along with all the other paperwork they have to give their clients or patients, they have to add one piece of paper to that stack.
But, Your Honor, that is, this court has recognized that is a form of speech, and to be required to...
Your bottom line argument is any burden, no matter how minor, is, and that's a perfectly fine argument. It's a matter of principle. Any burden, no matter how minor, is going to outweigh the state's interest here.
Yes,
you can
Your
answer
Honor.
that question, and then that's it.
Yes, Your Honor, but because we don't think it's so minor, we think you should apply strict
All
scrutiny.
right. Thank you. We'll hear from Mr. Martin.
Mr. Chief Justice, and may it please the court. My name is Dennis Martin, and I'm appearing on behalf of petitioners. As my co-counsel just explained, we believe this law should be subject to strict scrutiny. What I will argue is that this law fails any level of heightened scrutiny, including intermediate scrutiny, but also including the balancing test that you suggest, Mr. Chief Justice. And that's because this law is under-inclusive, it's also over-inclusive, and the state has a variety of less restrictive alternatives by which it could effectively accomplish its interest in informing women about the reproductive health care programs it provides. So I'll begin with the ways in which this law is under-inclusive, and there are two. The first is that this law leaves unregulated too many types of reproductive health care providers. Now, the state suggests that essentially there are only two categories of health care providers. There are
Yeah, that
those that
seemed like an awfully strong argument by the state, that both of these exceptions are perfectly rational. I mean, they're intended to avoid preemption, and they're intended to avoid redundancy.
Your Honor,
What's the problem with that?
we agree that both of those exceptions are perfectly rational. It's the other exceptions that we take issue with.
So, okay.
So you're
So
fine.
take those off the table, right? Those are okay? They don't support your argument that this is under-inclusive? You don't need that for your argument? Because that's not the way your brief reads.
Yes, Your Honor. We would note
What do you
that...
mean? What do you mean, yes? You agree with me that's not the way your brief reads?
No, Your Honor. That is the way our brief reads.
Thank you. Yes.
We agree that in the context of this law, and as the mandatory notice is written, both of those exceptions make perfect sense. However, when you look to the services that the mandatory notice...
I just want to go back to the exceptions
Yes,
before.
ma'am.
So it's the exception that allows Planned Parenthood to go unregulated, right?
One of the exceptions allows Planned Parenthood to go
Okay, so you're
unregulated.
fine with the fact that this does not apply to Planned Parenthood?
Well, Your Honor, the reason Planned Parenthood is exempted is because they provide all of the services listed
Right,
in
they're
the
not
mandatory
You're
notice.
fine
exempted.
with-
They're not exempted, right? In practice, they provide these services. So there's no reason to apply the law to them. It's not an exemption. It just doesn't apply to them, right?
Well, Your Honor, they provide abortion, contraception, and prenatal care,
Right.
but they don't provide all of the reproductive health care services that the state of California offers through Medi-Cal and FPACT. In particular, they don't offer postpartum care, breastfeeding training, and midwifery services. These are services that are provided by the state of California and that support a woman who chooses to carry her pregnancy to term, but that aren't listed in the mandatory notice. And so that's one way in which this law is under-inclusive. It doesn't effectively inform women about...
So you wouldn't object you wouldn't object to posting the notice if it listed more state-funded activities, or more state-funded programs beyond just abortion and contraceptive services?
We
Is
think
that your
would
point?
we think that would be a more effective law, Your Honor. And
You would be here challenging that also. Come on, that's
We would be, Your Honor.
not a credible argument, right?
Well, we would maintain that it's still compelled speech and that it's still viewpoint
Yeah, so,
discriminatory.
okay, so we've eliminated two basic arguments from your brief now. Well, the two exceptions plus this one, what's left?
Well, there are the other exceptions as well, Your Honor.
Yeah,
So
what are those?
this law applies only to clinics that are required to be licensed under Section 1204 of California's Health and Safety Code. But
Right,
that section of the code exempts a variety of other healthcare providers, including hospitals, private practices, local government clinics, clinics affiliated with universities, and clinics affiliated with hospitals. None of those healthcare providers are required to post the notice, regardless whether they participate in Medi-Cal and FPACT or not. And the state has never given us any reason to believe that a woman who is unaware of the healthcare programs that California provides is more likely to go to a pro-life clinic that's regulated by this law than, for example, a hospital that's unregulated by this law.
so can you imagine a notice that advises people of these state-funded services that would be constitutional in your mind? Can you think of any way in which the state could do this without being under or over-inclusive?
Your Honor, quite candidly, it's our position that any law that requires our clients to inform women about the availability of state-funded abortions is unconstitutional compelled speech. However, a law that applied to all healthcare providers in the state of California and listed all of the reproductive healthcare services that are covered by Medi-Cal and FPACT would be a much closer question because it would solve this under-inclusivity problem, and it would much more effectively advance the state's interest.
But it wouldn't solve what you consider to be an over-inclusivity problem, right? It would still be reaching people, lots of people who are not in the market for pregnancy services at all. And you think that's a fatal flaw?
Yes, Your Honor.
I don't understand that. Are there any kind of required notice? Again, I'll just go back to state laws that require people to post public accommodations, to post notices about public accommodation, anti-discrimination law. You have a right not to be discriminated against based on these protected classes, and here's a number to call if you feel your rights have been violated. Are those unconstitutional because they reach a lot of people who don't fall within a protected class?
No, Your Honor. We think those would be subject to strict scrutiny under this court's holding.
Okay, but why aren't they over-inclusive? Lots of people have to read them, or they have to post them. Lots of people will have access to them who are not covered by a protected class. Their rights can't be violated.
Right, Your Honor. I think this government has generally determined that requiring employers to post those signs is the least restrictive means of effectuating its interest in protecting against discrimination. The way in which this law is over-inclusive is relative to the informed consent provision that this court upheld in Casey. Right? In Casey, the informed consent provision was required to be delivered only to women who were about to undergo a particular medical procedure, an abortion. Here, women who aren't seeking any medical treatment at all, but are seeking one of the non-medical services that the clinics we represent provide, emotional counseling, clothes or food for their children, are still required to be given the notice.
No. I saw that argument in your brief, and I was curious about it, because you say required to be given the notice, right? All they have to do, two questions. Number one, they don't have to give it to them. They just have to put it up on the wall, right? But how can it be that, let's make sure I understand your argument. How can it be that, let's assume for a minute that it's constitutional with respect to women seeking pregnancy-related services, okay? How can it then become unconstitutional because a woman not seeking that also happens to come into the clinic?
Your Honor, our position is merely that...
Did I misunderstand your argument?
No, Your Honor.
Oh, well then, that doesn't make any sense to me. How can it become unconstitutional? Because some women, as you point out, enter the clinic seeking non-pregnancy, baby clothes, and other services that have nothing to do with pregnancy.
For two reasons,
Yeah,
Your Honor. The first is just that a law that was required to be given only to women who were seeking pregnancy health care would be a more effective law.
How would you do that in a clinic that provides both? I mean, then I take it the law would have to say, you can't post it. You have to actually hand it to the woman. Is that right?
Yes, Your Honor.
Now, let me stop
Wouldn't
you
that
there.
be even more intrusive from your point of view?
It would be more tailored to the interest that the state
But
asserts.
far more intrusive. Now you don't have to, all you have to do is post it. This would require your employees to actually take out a piece of paper and hand it to a woman seeking pregnancy-related benefits, which would be a far more, which engage your employees far more in the act of abortion. I think you'd really object to that.
That's true, Your Honor. I think the invasiveness of that alternative
Yeah.
is sort of beside the point because
I only raised it because you did. That was your point, that this thing is over-inclusive.
Well, the point we mean to make by it, Your Honor, is that intermediate scrutiny serves as a sort of backstop to viewpoint discrimination analysis, and that it helps to smoke out impermissible state interests. And so if the state says that what it's trying to do is inform women about the reproductive health care programs it provides, then we ought to ask whether the law that it has chosen to enact effectively does so. And
Well, can I just stop you? So tell me what the state should do, in your view.
yes, Your Honor, there are two alternatives by which the state could equally effectively accomplish this interest. First of all, it can use government speech to inform women about its health care programs directly. It can do so through a public advertising campaign. It can hire government...
Well, the state says that that's insufficient here.
That's true, Your Honor. Traditional TV and maybe radio advertising has been tried by the state, but they haven't tried, for example, advertising over social media or Google. They could pay for advertisements associated with particular keywords so that when a woman searches for an abortion provider or for reproductive health care, right there alongside the search results appears an advertisement for the state's Medi-Cal services.
What would you think if they put a sign up outside each of your clinics?
We'd
In other words, they put a big sign up in front of the clinic on state property.
Yes, Your Honor.
Would that be okay, or would you object to that?
It would be constitutionally permissible because it's government speech on public property.
Right.
We'd fight it at the ballot box, but we'd have a losing argument in front of this court, Your Honor. And there's no reason that that law would be any less effective than the mandatory notice that the state has chosen to adopt in this case. Moreover, Your Honors, to the extent that the state is concerned about any clinics that might, I see my time has expired. May I briefly conclude that
You can
thought?
finish your sentence, yes.
Thank you, Your Honor. The state has targeted
Or you
enforcement
can eat up your
tools.
rebuttal, whichever you like.
I prefer not to do that. The state has targeted enforcement tools to the extent that it's concerned about particular pro-life clinics. Thank you, Your Honor.
Thank you.
Mr. Chief Justice, and may it please the court, my name is Mark Krass, and I represent the California State Respondents. Your Honors, I will explain why this court should apply its standard from Casey to this law, and alternatively why it should apply intermediate scrutiny. My co-counsel, Jane Kessner, will explain why this law is constitutional regardless of the level of scrutiny that this court chooses to apply.
So, counsel, can I just jump in here? So your argument, at least I understand it from your brief, is that Casey is it. You win on that argument alone.
So we believe that Casey is governing precedent in this case, but we also believe that Casey articulates the right rule. And that's because states need latitude to perform their traditional regulatory function in the medical sphere. That function includes ensuring that patients understand their options before they make significant medical decisions. So we not only think that Casey provides the precedent in this case, we think that Casey gets it right here. And Casey also provides the appropriate limits on state action. Casey says that states are permitted to require informational disclosures as long as they are factual, non-misleading, and germane to the practice of medicine. And we believe that that provides a clear guidepost for states to be able to regulate medicine in the way that they
You
need
need
to.
your professional, so you're moving it, yeah. So that's what troubles me about your argument, is that the brief sounds like you rely very heavily on on the notion that somehow professional speech is less worthy of First Amendment protection, right? That's the bottom line of your brief, isn't it?
We make a narrower argument than that, but
Yeah,
yes.
but that's basically it. So, and you concede that this court has never, I mean, we've never gone there, right? And we've passed up some opportunities to do it. We've never really held that professional speech is less worthy of First Amendment protections. And I didn't see in your brief any really convincing reason why we should. And the thing that bothers me the most about it is that I can't get my mind around why we would treat professional speech of a licensed professional any different than the speech of any other state licensed person. You know, whether it's a barbershop or whatever, there's many state licensed activities, and you need to explain to me why we would treat what it is about professional speech that makes it less worthy of First Amendment protection. I didn't see that in your brief.
So, Your Honor, we would make a narrower argument about the medical field in particular. The difference between a doctor's office and a barber shop is that when patients come to a doctor's office, what they expect is a uniform standard of care, one that's guaranteed by state law.
Well, that's true of barbers. There are state standards that are enforced against barbers, and also for doctors, and I assume you're making your argument about lawyers also, doctors as professionals are subject to their own self-adopted professional standards.
Your Honor,
they're a self-regulating profession. They, in many ways, you could argue, are less in need of state supervision.
So 2 points on that. First, doctors are not self-regulating in California. They're subject to a wide variety of state laws that hold them to a uniform standard of care. California does not permit the medical board to make its own regulations entirely. California supplements those regulations with a variety of laws designed to fill particular gaps in the informed consent process, and that's exactly what it's doing here. But
Why are you throwing out the barbershops? I would have thought your argument was, of course, the state can regulate barbershops. They can require barbershops to put up a notice saying, some safety risk involved with chemicals that the barbershop is using in its dyes. Why wouldn't they be able to do that?
Your Honor, that's possible, and we do not concede that, barbershops are not subject
They're
to greater
licensed by
state.
the state, right? It seems to me it would fit very comfortably in your theory.
That's entirely possible.
Well, that's why I asked the question, because, if you want this court to adopt a standard, a professional speech standard here, we need to be sure we understand the consequences of it. And my question was based on just that. In other words, if we adopt it, are we really basically saying any state licensed activity is entitled to less First Amendment protection?
We think that the key would be undertaking a fact-specific inquiry into the profession in question. So it's not necessarily
now that doesn't help me limit this decision. I mean, what does that mean?
That means that
what are the facts that I would look at here that would distinguish this from the barbershop?
So you would try to understand what citizens expect when they access that professional services. I mean, people certainly seek advice from their barbers, but they may not expect that advice to be good.
I get great advice.
When people go to their doctors.
I get really good advice from my barber pretty regularly, and it's sometimes better than anywhere else.
Yeah, well, that may be, but when people go to their doctors, what they expect is accurate medical information and to be told about all of their medical options. In other words,
Well, let me ask you about that. Does California require that clinics that perform abortions provide information about financial assistance that might be available with respect to childbirth?
that is not part of this disclosure.
Okay, so if a woman can make an informed consent, informed consent to an abortion procedure without knowing about financial assistance for alternatives, why is it the case that a woman cannot give informed consent to childbirth without knowing about financial assistance that might be available for the alternatives?
So to be clear, our position is that physicians should discuss all of the options in both of those cases. The reason why we passed this particular regulation is because we have no information to suggest that women lack information about childbirth. But in this case, there is information that women don't understand the full range of reproductive health
Did you
options.
look? I mean, did the legislature do a study about whether women who have abortions are aware of financial assistance that might be available if they choose to carry their pregnancies to term, or whether they are aware of adoption services and things like that?
It did not, Your Honor, but the reason why we suggest that this court apply the Casey standard and not a higher standard of review is precisely to allow the legislature the latitude to solve the problems that it thinks are the highest priority.
Well, that's the argument all state legislatures make. This is a constitutional case, and the question is whether the state can accomplish that fundamental goal, and I accept that it's fundamental, against the First Amendment rights of these clinics. That's the issue we are facing here. And so, but just to continue on the professional speech thing, the petitioner says this isn't even the right case to talk about some sort of professional rule, because when the woman walks into the clinic, there's no professional relationship yet. And that's what they argue. They rely on NAAC button, and they distinguish Casey on that ground.
So 2 answers to that, Your Honor. First, on the facts, clinics are only required to provide this disclosure to clients. So nobody who is not a client, the FedEx man, for example, who walks in the door, is not required to receive this disclosure.
Wait a minute. They have to post it. One thing is to just post it in the office, right? That's for anybody who comes in.
They only have to post the notice if they decline to use the other means of disseminating the notice. So if they don't want to post it, they don't have to. They can hand the notice to clients on a sheet of paper or on a digital disclosure. So that's a factual matter.
Okay, that's a good point. Okay, yeah. So you ask your question, and then you go ahead. You keep going. Go ahead.
So, but more broadly, Your Honor, the state needs the latitude to ensure that licensed medical professionals provide the disclosure in an effective way. And in this
Can I
case,
just stop you there, though? I believe your opponents argue that the notice has no relationship to a licensed professional here, because it's, I think,
Right.
following up on Justice Tatel's remark, is that it's on the wall. It has nothing to do with a doctor. Most of these people haven't met a doctor yet. So can you respond to that?
the only issue with that argument, Justice Ide, is that these are licensed medical clinics. The entire reason why they're licensed is because they provide services through physicians and through other licensed medical professionals. So if a client is coming into a licensed medical facility, we think it's a reasonable inference on the part of California to assume that they're there for medical services. And so the idea that the fact that they have not met a doctor yet is sufficient to defeat professional speech simply doesn't comport with the core idea of professional speech, which is to protect patients when they go to facilities that provide medical care.
Can you prevail if we don't agree with you about professional speech?
Yes, Your Honor.
Do we have to strike this down?
No, Your Honor. So there are two arguments on that. First, even if this court declines to apply professional speech, it can still apply intermediate scrutiny in recognition of the competing interests at stake here. And we feel that would be appropriate because this case is closely analogous to the similar area of commercial speech, where the court has similarly recognized strong state interests in regulation.
So your mentioning of intermediate speech triggers me to ask the same question I asked counsel for petitioner, which is, what do you think about my concern about this court's jurisprudence on strict versus intermediate? Do you think my concerns about that are correct, and that maybe we should shift to a more core focused inquiry where we simply balance one interest against the other and strip away all these false non-objective standards that we have created for ourselves? What do you think of that?
Your Honor, I
Do you think we'd all be better off?
There may be virtues to that approach. I think the key issue from Respondent's perspective is its administrability from the perspective of the state legislature. The state legislature needs to know what's allowed and what's not. And the clear boundary lines that are set out in Casey do that in a very effective way.
Well, but those boundaries would evolve in the case law as we balance different state interests against different First Amendment interests. Over time, the boundaries would become quite clear, which is, the way courts address questions like this. But yet we'd be looking at the core question. We'd be accepting the notion that there are really important issues on both sides of this, and we would be carefully balancing one against the other. And
The way the court did in Casey.
what do you think about that?
So like I said, I think the cognate area, for example, of commercial speech, where this court has done its best to lay out a clear area in Zotterer, where states are allowed to compel factual disclosures, we think the wisdom in that is the clarity for the legislatures. But even leaving that aside for a moment and addressing the core issue, the reason why this case does not pose classic First Amendment concerns is precisely because the doctor's office is a place where patients expect to get all the information in an unbiased way. It is not like a sidewalk where patients expect, or where citizens expect to be able to engage in unmitigated political dialogue. It's a place where patients already expect the state to be acting.
Okay, this is all very powerful. I understand that, but we have to balance that against the very fundamental First Amendment right raised by the petitioners here. They've raised a very important constitutional issue here. Their objection to participating at all in a process they believe is evil.
So, Your Honor...
And I haven't heard from you here or in your brief yet how we balance that, other than your brief simply restates the importance of the state's interest. It doesn't accommodate the other interest. And that's what we're asked to do as a court.
Our proposal is that this court balance those interests by clearly delineating where the scope of medical practice begins and ends, and by outlining where it is that doctors can expect to be subject to greater state regulation. Petitioners' clients can have confidence that when they are not acting in the scope of their license, they are permitted they're permitted to be free from any state requirements about what they must disclose to patients or anyone else for that matter.
What would that look like, though? What does that space look like?
So, Your Honor, firstly, obviously, when petitioners are not inside their licensed medical clinic, they're free to say whatever it is that they want. But furthermore, this...
Well, I assume they're concerned about what is at issue before us, which is within the clinic. So help me understand that.
So there are two limits on that that flow from the scope of medicine argument. The first is the idea that the state can't force the doctors to talk about things that are too far afield from medicine. The state cannot force, for example, petitioners to talk about, why they should vote for President Trump in the next election. They have to stick to medical facts or facts related to medical decisions, and that's what California has done here.
This isn't a fact about a medical practice. It's a fact about state law, right?
We would disagree with that, Your Honor, as doctors have increasingly realized if a patient is not aware that a medical alternative is financially feasible, then that option is not really available to the patient at all. So when we talk about the purpose of medicine as being to give patients the opportunity to make an autonomous choice about a medical decision that's standing before them, understanding all their options is a core part of that, and financial feasibility goes right into that category in our view. So, and that's very similar to what this court held in Casey. Your Honors, I see my time has expired. May I briefly...
I have a quick hypothetical. Well, never mind. Your time is up. You can finish that. Go ahead.
Thank you.
Yeah.
That's exactly what this court held in Casey when it permitted the state to require disclosure about child support and about adoption.
Go ahead.
Thank you.
Yes. So...
Mr. Chief Justice, and may it please the court, Jane Kessner for respondents. Your Honors, regardless of this court's finding as to the appropriate level of scrutiny, the FACT Act remains constitutional. It survives even strict scrutiny and thus easily withstands intermediate scrutiny. Hundreds of thousands of women in California have unplanned pregnancies each year, leaving them to make difficult decisions about how to proceed. That's why the legislature enacted the FACT Act to, quote, ensure that California women make their personal reproductive health care decisions, knowing their rights and the health care services available to them.
Okay, you go ahead.
No. I defer to the chief.
All right. So, all right, I accept. Let's take the argument as you just put it. We'll start with strict scrutiny. And I accept what you just said. I think you're right. But the question I have is whether this notice is really the least restrictive means of accomplishing that. That's what bothers me. And the reason it does is the only thing I saw on the record about this is that the state has tried some sort of advertisements, right? And that hasn't been effective.
Right. That's
at
right? Page 39 of the record.
Yeah, but that's it. Or is there anything else?
So the record discusses that the state has tried many kinds of advertisements that hasn't been effective. So the point of this act is to supplement the efforts that the state already has.
Right,
but I can provide other information about specifically why we would think generalized advertisements will not be effective here.
Yeah, but is that in the record?
So the record does not include all of the detailed information that I can discuss if you'd like, but there is a legislative finding that California needs this act to supplement the efforts it's already taken.
Right, I saw that. And the only reason I'm pursuing this question is it seems to me if we're at strict scrutiny, which you started your argument out accepting, at least for purposes of argument, then it has to be the least restrictive. And when we're talking about a really fundamental First Amendment right, it seems to me this court, ought to insist that the state has actually explored other alternatives.
So,
to be sure there are no other alternatives. And the only thing, and correct me if I'm wrong, that I see in the record here is that the state has tried various kinds of generic advertising, correct?
So first, I would point to the fact that there was an entire report commissioned that is discussed in the legislative history, in the record, the UC Hastings report, which discussed different alternative ways to address this problem and found that those alternatives were not effective. The state did consider alternatives. And yes, the state has also undergone advertising campaigns, including the kind of technological advertising that Mr. Martin discussed. For example, the state websites do already come up when you Google them, when you Google, abortion care California and that sort of thing, but so do the websites of these regulated clinics. So that technological targeting alone is not effective, and the state has found that it needs to supplement its efforts.
Well, why couldn't the state just put up signs outside each clinic?
The billboards outside each clinic. So first, I'd point to just sort of the absurdity of that suggestion. We don't.
Whoa.
Because if you were to universalize that, for example, to OSHA postings, right?
Well,
then you
we're
would
not
think
talking
that,
about OSHA. We're talking about how many clinics are there in California?
there are hundreds of clinics in California.
Yeah, like 100 and what? How many are there?
It depends on how you
We're not
define
talking
the
about
clinics.
that.
If you're talking about clinics that are covered by the Act,
Yeah.
that actually includes Planned Parenthood, for example.
No, I'm not talking. No, those clinics are happy to put up your ads, your notices. I'm only talking about these clinics, the clinics that resist, that don't
Right.
want to do it. Those clinics, you put up a poster outside
So
on
first,
state property.
as the justices pointed out, we think that the petitioners would object to that as well.
Well, no, they said they wouldn't. They
well-
said they'd challenge it at the ballot box,
First,
but not in this court.
First, we're not sure of that, Your Honor. Second, it would be extremely expensive. That's not what we require legislatures to do. We don't
But
require them to put up billboards every time they need to post a notice.
Well, why not? If we're talking about protecting a fundamental First Amendment right, why not? I get your point if there's no constitutional right at stake here.
So
You're totally right about that.
Let
but
me speak to some
why
of the...
shouldn't this court insist that states exhaust all other remedies before they force an entity like these clinics who sincerely believe that posting this notice is offensive? Why shouldn't we be sure the state has done everything it can to satisfy us that there's no other way to educate poor women about their rights?
Because then there could never, if we literally make the state go one by one through hundreds of possible alternatives before they do anything, they could never accomplish their goals. And
I was
even under
only
strict
asking you
scrutiny,
about one alternative.
even under strict scrutiny, we don't force states to just sit on their hands and wait to see the billboards failed. So example, in Burson v. Freeman, this court upheld a prohibition on campaign-related speech within 100 feet of a polling place under strict scrutiny because it served the compelling interest of protecting voters from confusion and undue influence to safeguard the right to vote freely, even though there was limited evidence of actual intimidation or electoral fraud. So the idea there is that states can take prophylactic legislation to reach women in the most direct way possible, in the waiting rooms of the places they actually seek pregnancy-related care.
Suppose the anti-vaccine people, where they're in Berkeley, suppose they take over the state legislature and pass a statute requiring that all healthcare providers in the state post a notice in their offices that vaccines cause mental and other disorders in children. And it's challenged by a doctor who says that's unconstitutional.
So,
What would you think about that?
so if that information is medically inaccurate, then there are some protections in the case law that would account for that.
My hypothetical includes the legislature holding hearings, hearing from experts, and ordering the vaccine, and ordering this notice.
So if it's not actually medically inaccurate and there's medical suggestion that that is good, that vaccines are actually terrible for patients and don't have all of the benefits that we generally know vaccines to have, then at least in the Casey world, which Mr. Crass was discussing, that kind of notice would be acceptable. In Casey, for example, the sorts of notice that they were passing were actually on the other side of the ledgers, the kind of notices that petitioners would want. So we think that at least in that world, that sort of vaccine notice would be acceptable. But I'd like to turn to another argument that petitioners make a big deal of, and we'd really like to address today. And this is the idea that there are all of these exemptions built into 1204 that mean that women aren't actually getting this information, only women at these clinics are. And that's not true. And we'd like to point to the fact that California already guarantees that patients who seek care at providers not covered under 1204, so hospitals or private doctors, are provided information about the range of reproductive health care options through an alternative statutory scheme. So under California Health and Safety Code 1363.02, every insurer in the state is required to provide insured persons with a notice informing them that some hospitals and other medical providers in the service area do not provide the full range of reproductive health care options, including abortion, and provide them a phone number explaining that they can call to find out which hospitals and providers do provide those services. So this statutory scheme already exists and reaches any women who seek care through insurance. But the reason that CPCs and other sorts of clinics, 1204 clinics, present a gap that needs to be filled by the legislature is because those clinics do not go through insurance. They provide free or low-cost care. So women who go to those clinics don't get this information that these reproductive services are out there from their insurers or from Medi-Cal, because Medi-Cal has to provide it too under the California Welfare and Institutions Code. So this legislation actually doesn't have all of these exceptions. Rather, it fills in a gap in a statutory scheme that has actually existed since 2000.
It does have the exception, right, for establishments that are already participating in these state financial assistance programs. I understand that the state thinks it would be duplicative or redundant, but I guess my question is, so what? To make this thing look even-handed, and in fact to make it even-handed, why not require those entities to put up the notice too? What's the harm? Your Honor.
First, it's already even-handed. There are actually 14 Planned Parenthoods in California that do not subscribe to Family Pact and Medi-Cal, so they are required to post this notice. For example, Planned Parenthood in Thousand Oaks does not subscribe and thus is subject to the FACT Act.
They don't have any First Amendment objection to the notice.
Sorry, Your Honor?
They don't have any First Amendment objection to the notice.
If the petitioners are right
The
about
only
what the First Amendment
the only entities targeted by this are entities that object to it. Isn't that right?
No, because my point is that Planned Parenthoods are also covered. It doesn't matter if they object; they're still subject
That's
to
my
the
point.
Act.
The petitioner argues that this is targeted at them.
Right.
My question was trying to get at the point that, in effect, the way the state did this, it originally started out proposing to cover just clinics. It was advised by Hastings not to do that, so it didn't. Then it created these exceptions. And the result is exactly what they intended at the beginning, namely the impact of this statute is really only on those entities who have a First Amendment objection to the notice, because everyone else is either already doing it, willing to do it, or doesn't need to do it.
So
that's their argument.
But the only
what's the matter with that?
Sorry, the only reason that the impact falls upon 1204 clinics is because they weren't subject to this previous statutory scheme, and this impact does still fall on Planned Parenthood. So, for example, if there's a Planned Parenthood that just disagrees with the idea of having to post government notices in general, like a libertarian
Is there such a one?
Planned Parenthood.
That's
right. Imagine a
interesting.
libertarian Planned Parenthood, right?
Do you know of one? Well, if there was one in the record, that would be a really interesting point, but
there's a Planned Parenthood.
I think the notion of a libertarian Planned Parenthood, that's a really interesting concept.
Why not? There's a Planned Parenthood
sure,
that thinks women should have all
of
their
can't,
options. They
but
should
we
get
can't,
free choice,
yeah, but we
including
can't,
the choice of an abortion.
We can't decide this case on the basis of a hypothetical libertarian Planned Parenthood, as intriguing as it is.
So maybe we don't know, it's hypothetical that they're libertarian, but what we do know is that there are Planned Parenthoods that do not subscribe to Family Pact and Medi-Cal, and they are still covered by the notice. But to get back to the core of your question, Justice Harris, the reason that this is redundant and also that redundancy matters is that it's not just that these clinics that enroll in Family Pact and and Medi-Cal provide some, wider range of services. It's also that because they're enrolled in Family Pact and Medi-Cal, they're contractually required to counsel women about the range of Medi-Cal provided services, even if they don't provide all of those services themselves. So the substance of the notice is already communicated, just like it's communicated to women who seek care through insurance or Medi-Cal at private hospitals, private doctors, religious hospitals even.
But still, it would do no harm to have that notice hanging on the wall, or do you think it would? That's what I'm getting at. Is there anything more than redundancy here that explains this exemption? I mean, that's my question. Or is it just, because a big part of your argument is, look, it's really no burden, it's no big deal. What's the harm in having it on the walls in all these clinics?
Redundancy is the explanation, and it's possible that if the legislature were asked to slightly change it so that it would make some of those clinics also post the notice, that the state would be perfectly willing to do so, but it didn't make sense as a legislative enactment, and it's certainly not enough to sink the law, given that they already are contractually required to communicate the same information.
Could a clinic comply with this statute by simply posting the statute in the proper format, 7.5 by 11, with the right text, right size type?
Yes, Your Honor.
It could. Okay.
By posting the statute,
Yeah.
Yes, Your Honor, that
Just
would still
make a
post
copy of the
notice.
statute and put it up on the wall.
So
right?
we think so. Admittedly, this is a preliminary injunction stage. We don't know what the actual enforcement would look like exactly, but based on the statutory text, it seems that would comply. Yes, Your Honor.
Okay.
So there's one more thing that I'd like to discuss before my time concludes, which is the reason why it specifically makes sense to target women who are in the course of seeking pregnancy-related care at these kinds of clinics. And here's the reason. Even though there might be some sort of generalized advertising campaigns, those are ineffective because many women become eligible for Medi-Cal only at the moment that they become pregnant. So for example, while Medi-Cal eligibility requires a family income of below 138% of the federal poverty line generally, that number increases to 213% for pregnant women. So pregnant women are more likely to be eligible for Medi-Cal and to have their status change when they become pregnant, providing a unique reason that we want to communicate to pregnant women or women who might be pregnant at the moment that they're actually seeking pregnancy-related care. And we also point to the fact that one of the problems that the legislature wanted to address here was this lack of information, but specifically in light of the risk of misleading practices by some clinics. Now, we admit that not all of these clinics are necessarily misleading, but there is evidence that some provide false information about the medical risks of abortion, and also that some advertise, for example, that they provide abortion services, or they use logos that are similar to Planned Parenthood's.
What do you think of the petitioner's argument that the legislature, when it passed this, relied on a major report by NARL, and that many of several members of the legislature were clearly pro-choice?
So we don't think the fact that some people who were involved in the drafting of the law had, a belief on one side or another of a political debate sinks the law. Many legislatures likely were not affiliated with NARAL. Sorry, I see my time has concluded.
Let me just ask you, do you think there are any situations in which this court could look at the statements of members of the legislature in determining?
So it's true that this court sometimes looks at legislative history. The court has gone back and forth about the extent to which to look at that sort of legislative history. And the concern is that the view that is expressed in the speeches of one or two members of the legislature might not represent the view of the legislature as a whole. In Sorrell, for example, the court did permit the parties to look. They did look at the legislative history, but only to supplement what was already obvious from the face of the law. But here, the legislature was clear about its interest.
In Sorrell, they didn't need anything from the legislature. The statute was plain on its face.
It was plain on its face.
Okay, so that
But
doesn't
here,
help.
the only evidence is the statement of a single member or, one report mentioned by one possibly biased party, and that's exactly the kind of evidence that the court warned about accepting in O'Brien. Thank you, Your Honors.
Fine, thank you. So we'll hear a rebuttal from Mr. Martin. So Ms. Kessner says you can just put up the statute on your wall. What's the matter with that? Doesn't that solve the problem?
No, Your Honor.
Just make a copy of it, 8.5 by 11 of the statute, stick it up on the wall.
No, Your Honor. For the same reasons that this court struck down Live Free or Die in Woolley, there was no confusion about whether that message was the state of New Hampshire's.
But that was a political message. This is just a fact. All they're doing, you're just posting a statute. Free, live, or die was a message from the state. This is just a statute, a fact.
It is just a fact, Your Honor, but facts can be used in blatantly political ways, and that actually goes to the consequences of the test that the state of California proposes here. They say that so long as compelled medical speech is factual, non-misleading, and germane to the practice of medicine, it should be subject only to reasonableness review. But consider a notice that California requires all doctors to place in their waiting rooms that reads, if the Affordable Health Care Act is repealed, 32 million Americans will lose their health insurance by 2026. That is factual, it's not misleading, and it's germane to the practice of medicine, but it's blatantly political, and it is ordinarily outside of a state's power to compel private parties to say.
Well, I agree with you that would be unconstitutional, but here all the state is doing is advising women who need financial help to take advantage of a fundamental constitutional right that the state will pay for it. That's all.
We disagree that that's all.
Well, I
Your Honor.
thought you would, but why?
We acknowledge that it's difficult to draw the line between innocent factual disclosures.
Drawing lines is what courts do, and this case presents that question for us.
That's
right?
exactly right,
Yeah.
Your Honor. And we think the line this court should draw is the same one it drew in Reed, that compelled speech, content-based regulations are subject to strict scrutiny. And the state has not shown that this law is likely to be effective or that it's necessary to accomplish that.
Yeah, I'm still worried about the limits on your argument, so let me give you the reverse hypothetical about vaccines. Could a state, vaccines are a contentious, divisive social issue, could call it ideological. Could a state require pediatricians' practices that do not provide vaccines because they have some objection to post a notice just saying, state law requires that school children be vaccinated, here's a number to call for access to vaccinations? Could they do that?
Two responses to that, Your Honor. First of all, the state could simply require that all physicians in California provide vaccines. That's within its power to regulate professional conduct.
Well, say it doesn't want to do that because it is moved by the conscientious objections of certain pediatricians to giving vaccines.
Well, Your Honor,
It wants to accommodate religious freedom to the fullest extent possible.
we believe that to the extent practitioners wish to be accommodated is sort of dependent on their conscientious objections. And if doctors don't wish to carry the state's message, the state doesn't have power to compel them to do so. But second, Your Honor.
So those notices are not okay?
Well, those notices would not be okay if they were targeted at doctors because of their religious beliefs.
They'd be targeted at doctors because they don't provide vaccinations.
We think that's different than targeting doctors because of their religious beliefs.
Okay, it applies to all doctors who don't provide vaccinations. Parenthetically, the reason California doesn't require them to is because it's worried about those doctors who object for religious reasons. But the law applies to any doctor who doesn't provide, any pediatrician who doesn't provide vaccinations.
Then it's possible that law might survive strict scrutiny because of the
How
state's...
come? Wouldn't you say it's both under-inclusive because it doesn't apply to all pediatricians and over-inclusive because parents will see it even if their kids have already been vaccinated?
Your Honor, I see my time has expired. May I
You
briefly-
can answer her question.
Thank you, Mr. Chief.
I want to hear it too.
Yes, Your Honor. The state has a compelling interest in protecting against third-party harms from failure to vaccinate children. A notice on the wall would still suffer from the infirmities of being under-inclusive and over-inclusive,
Okay.
and the state has better means of
Okay.
targeting that law more narrowly. Thank you, Your Honors. We respect.
Thank you. The case is submitted. Well, we would rather decide this case than have to give these awards. And I'm very serious about that. Both teams were, and the court is unanimous on this. Totally extraordinary work. Congratulations to all four of you. But we have to earn our pay and grant these awards. So we are to give 3 awards. First is Best Brief. That goes to petitioners. Best Oralist, Jane Kessner. Even though she did call the Chief Justice absurd. Just don't try that in the Supreme Court. Best Team, Respondents. Judge Harris?
I just want to reiterate what our Chief Justice said. I thought all 4 of you were extraordinary. I was incredibly impressed, both with the briefs and with the arguments. I thought, I'll just say a few general things, but really I just want to emphasize how amazing you all were. I thought in both briefs you made important strategic choices rather than trying to cover the entire waterfront, and that was really, really good. I thought you both focused in on, you know, the best way to present your case, and you left some of it to the side, and I thought that was very smart. I thought at argument, you kind of leaned into the questions. You didn't try to avoid anything. You answered the questions. When you had to give up a hypothetical, like, yeah, you bet, no pediatrician's notices, sorry, Judge. Like, that was the right thing to do, and you were sort of honest about the breadth of your arguments in a way that I thought was very helpful. I thought you both had hard cases to argue. Both of them, for a judge, you want some limits on these positions, and there are no really easy answers to what are the limits on either set of propositions in this case, and I thought that was a hard thing that both of you had to face at argument, and you did really well with it. I thought we were a very typical bench. We had some kind of wacky questions. Some of the, I assume you were being Justice Breyer, like, what if we just got rid of all the doctrine? But you guys rolled with the punches, and the last thought I want to leave you with, I think you can go through law school and you pay a lot of attention to the Supreme Court, and you think in terms of the Supreme Court, and you think in terms of Supreme Court advocacy, and these days, Supreme Court advocacy is so good, thanks largely to entities like the clinic you have here. Any of the 4 of you, if you walked into the Fourth Circuit today, you would be among the best lawyers I saw that year. You all should know, the 4 of you and all of the students here, there is such a need for a high-level advocacy in the courts of appeals, and a good lawyer, a good law student can make a huge difference almost immediately, at least in the Fourth Circuit. And we have many, many excellent lawyers. Please don't understand me to be saying anything other than that, but but not every person who comes before us in the Fourth Circuit has an excellent lawyer. We are not there yet, and all 4 of you, if you walked into the Fourth Circuit, I would be so happy to see you there. So don't forget the Courts of Appeals when you go off to your amazing careers.
Well, I concur. You were amazing. Seriously, it just was so impressive. You're also welcome to the 10th Circuit, just in case you're thinking that you should only go to the 4th. I just wanted to say a few things just individually. It's just so hard to go first. Well done. You know, it is very difficult because I think nobody's warmed up, nobody's thinking about the case, and then boom, so you did extremely well on that. I like the line of challenge in the ballot box, not in court. That was a really good line, and I think it showed that you were willing to concede, and I think this goes for everybody. You're willing to concede where you should concede. There's no use spending all your time fighting an argument that really isn't essential to your case, and it's really nice to see people willing to concede when they need to. I also just, back to Justice Breyer here, you were excellent in just saying, well, that might have some virtues to it. It's actually crazy. But, that was really well done, I thought. And then the absurdity of the billboards, that actually I thought worked really well in the sense that you had some passion about your argument, and you weren't going to go there. And sometimes that's the most effective thing to do, and I thought it just was excellent today. Just to summarize, you were terrific. So thank you for the privilege of inviting me here today. And I just wanted to add one thing. It's just been a pleasure to be with this panel. So thank you, everybody.
So, in my own defense, the question that may have been absurd, but it was designed, as many questions are by a court, to get to a very important question, which is what I was trying to do was to test the limits to which we should push a state legislature when it's intruding on a First Amendment right. And that's what happens at oral arguments. That's what judges do. And in the end, I thought the answers to it were just fine. But that's what questions like that are for. I want to make it, obviously I agree with both of my colleagues about what a superb job the four of you did here, and you should all be very proud of your accomplishments. I want to make a general point, both for the four of you and for everyone else here. What you saw here was a moot court, but nonetheless a window into what is perhaps, I think, the most exciting and intellectually disciplined part of our judicial system, namely an oral argument before an appellate court. And when it's done well, as it was here, what you see are three prepared judges struggling to decide an important case with the help of two, in this case, four well-prepared lawyers. And what I mean by that is each side, the lawyers are representing their own clients, and they have a professional obligation to do that zealously. But they're also officers of the court, and they have an obligation to make their arguments accurately, conscientiously, and responsibly. That is not to overstate the law, not to misstate the record, to be candid about the facts and the law they're dealing with, while they're zealously representing their clients. And all four of you did that today. And that, to me, was what was most impressive. And that was true of each of you. You were all zealous advocates for your clients. Once or twice a little more zealous than necessary, but really zealous. But the really important thing, and I hope you all noticed it, it came up in the questions. They all candidly answered the questions. No one distorted the facts. No one distorted a case. Even when they were on the defensive, they were accurately accepting what the case law is. And you saw them make concessions, which is one of the most difficult things for lawyers to do. And so to the four of you, congratulations. You did a really great job. And your law school should be, your dean and your professors should be very, very proud of the four of you. So, thank you.
We're just going to do some photographs. Yeah. Yes, robes on, definitely. We need the full judicial.